Hello, and thank you for joining the Understanding Procurement and Vendor Management session. My name is Jasmine Lewis, and I'll be helping to moderate this session. To get started, I would like to invite the presenters on camera for brief introductions.
Good afternoon, everyone. My name is Kevin Roddy, and I'm a technical director with ICF. I have been working in affordable housing and community development for over 30 years, and in fact have been participating in support of disaster recovery and mitigation programs for approximately a 10-year period, harking all the way back to Hurricane Katrina. Deb?
Hi, my name's Deb Seifert, and I am a director in disaster management with ICF. I started working with CDBG in the entitlement community back in 2000 and moved to CDBG disaster recovery in 2006. Worked with Kevin on the Katrina recovery and have worked on several recoveries since. And I'm very excited to be here today to problem solve with everyone.
Good afternoon, everyone. My name is Tiara Howard, and I am a Senior Community Development Specialist with ICF. I've been with ICF for about a year and a half, and I have a great amount of experience administering home and CDBG programs, as well as I used to be the Section 3 coordinator for one of the entitlement communities that I used to work with. So I look forward to talking to you more about Section 3 later.
Thank you, Kevin, Deb, and Tiara. For today's session, we'll be providing an overview of procurement standards and of the new Section 3 final rule. For procurement, the objectives of the section and key requirements for soliciting and engaging contractors and vendors for professional services and capital construction, and grantees will gain knowledge of recent developments and best practices in procurement to avoid obstacles that can delay recovery. For Section 3, the objectives are that grantees will learn about the new Section 3 final rule requirement, gain an understanding of how the requirements apply to procurement and contract management, and learn best practices for implementation. The agenda will go as follows. Deborah and Kevin will present on, procurement standards, and will be followed by Tiara, who will provide an overview of the new Section 3 final rule. And I'll come back to provide helpful resources and also to moderate the questions and answers. So with that, we can get started. I will hand it back over to Deborah.
All righty, so this is a very exciting and very important topic, and that's procurement, because so much of your recovery starts with doing a proper procurement and making sure that you keep that procurement and that contract compliant throughout the life of your grant. So we're going to start with some procurement basics. So the procurement regulations for CDBG grantees and subrecipients start in 24 CFR 570, which are the CDBG regulations, and specifically Part 489.D and Part D and G are for states. This gives the instruction to the states on how to administer the grants and how to procure under federal regulations. And also, we need to remember that the Federal Register notice allocating the funds also has specific requirements. So if you're a state grantee, you actually have to make a decision about the rules that will apply to yourself as you administer and also procure services for the state. And if you're a subgrant to the states or a subrecipient, then you're not actually given that option. You must comply with the requirements that are found in 2 CFR 200, which is the Uniform Administrative Requirements for Federal Funds, and the parts 318 through 327 are specific to non-state grantees. The non-state grantees must also refer to and know the requirements that are in the Federal Register notice. So appropriation-specific requirements are in each Federal Register notice allocating the funds, and these requirements do have the force of a regulation. Next slide, please. All right, so we're going to look at procurement by states. And again, as I said, states must decide which procurement standards will apply. So that means they have the option of looking at their own fiscal controls and accounting procedures and to see if those accounting procedures align with the federal requirements under the 2 CFR Uniform Administrative Requirements. So actually what will happen as part of your action plan process is there will be a certification of financial controls that will be submitted prior to the action plan. And that's where HUD will review those controls to see if the state's own set of written policies and procedures for fiscal control and procurements align with the federal requirements. So they'll make sure that they're specific enough to ensure compliance. They'll also make sure that the CDBG-DR funds will be spent in a reasonable and necessary cost. And they'll ensure that the CDBG-DR funds are not used for general expenses outside of the actual funded projects themselves. And the state may also satisfy this requirement by, as I said, using their own requirements for their funds if they are determined to align with the federal requirements. They could identify some deficiencies and just adopt some new requirements to augment their current requirements, or they can choose to comply with the 2 CFR Part 200 sections 318 through 327, the same as the subrecipients or subgrantees. But once you do adopt a method, then that's the method you must follow unless you go through a process to amend that with HUD. Next slide, please. So under 24 CFR 570, which are the CDBG regs, Part 489G, that speaks specifically to states about the procurement. And first and foremost, it explains that states must be competitive in their procurement processes. And then there are some specific requirements as it regards to spending federal funds. And the first and foremost is that you cannot have a no cost plus a percentage of cost contract or percentage of construction cost contracts. These are prohibited under federal procurement and specifically under HUD federal rules as well. The state must also include standards for the conduct of governing employees that engage in the contract award or administration. And a lot of times you see this referred to as conflict of interest policies or clauses, and those are required. The state must also include any other clauses of federal statutes or executive orders or implementing regulations. And actually, we're going to discuss those in more detail in a couple of slides. The specific requirements can be found in the section 317 under 2 CFR 200. Next slide. So procurement by local government grantees and their subrecipients, again, as I said, they don't have a choice to follow their own procurement. They will need to amend any procurement policies or guidelines as it relates to expending federal funds to align with the requirements that are found at 2 CFR 200, 318 through 327. Also, local governments will need to be cognizant and understand the requirements of the federal law as it relates to state law and as it relates to their own local procurement rules. And as an implementation tip, it's a good rule of thumb to always go with the most stringent requirement. And if you can't determine what the most stringent requirement is, then follow the Part 200. So for example, a local government may have a threshold that requires them to have a formal competition in their procurement, and maybe their threshold is at $100,000, whereas under 2 CFR 200, that threshold is $250,000. And Kevin's going to go into more information about that, but I just give you that as an example. So in that case, the local requirement of $100,000 would be considered more stringent, and HUD would expect that you would follow the more stringent procurement policy. Next slide, please. So again, as we were talking about the procurement standards that are found under 2 CFR 200, sections 317 through 327. I'm going to go through these and I'm going to hit on a couple of the key requirements in each of these sections, but I implore you, and it is so important to actually get these federal regulations out and read them in their entirety, because some of the sections, such as 318, actually cover a couple of pages. So there's a lot of information in there, and we're just not going to have the time in this meeting right now to go into detail on any one of them. But let me touch on some highlights of each of these. So under 200-317, that is state procurement requirements. And that is basically where it says the state does have the option of following its own procurement processes for property or services when they're dealing with a federal award, or they can choose to follow the 2 CFR 200 requirements, 317 through 327. But it does say there explicitly in that section 317 that a state must include sections 321, 322, 323, and 327 in their procurement. And we'll talk about those a little bit more as we get to those. So when you get to section 318, as I said, this is a very long section of the regulations, of the Code of Federal Regulations, but this is about your general procurement standards. And some of the key items there, it discusses that you must have written, documented procurement standards. You must have a contract oversight process that's documented. You need to have written conflict of interest policy. You need to be cost effective when you're doing your procurements. You'll need to be responsible and have oversight over contractors. And as I said, there's much more in there. So it's very important to actually get that out and read it to fully understand all of the general procurement standards. Then when you get to section 319, that talks about competition and what's considered eligible and good competition and what's prohibited competition. And first and foremost, competition is to be full and open and available to everyone that's qualified. And it also explained in there that you cannot have unfair advantages for certain vendors. For example, if you have a vendor or a contractor assist you with putting together a solicitation and they're providing the technical standards and the scope of work, that contractor would not be able to bid on that procurement because they would have inside knowledge and understanding that would give them an unfair advantage over the other vendors that would be coming into this without that pre-knowledge. So this is what's discussed under competition in that section 319. And then section 320 actually goes into the different methods of procurement, and Kevin's going to really dive into those a bit more here in a moment. But at a high level, that's going to discuss, how these methods are determined based on dollar thresholds, and also the type of work that you're trying to procure. And Kevin's going to give you good information on that here shortly. And then under section 321, this is one of the sections that a state must include in their procurements. And this has to do with contracting with small and minority businesses, women business enterprises, and labor surplus area firms. So it's important to read and understand that section. Section 322 is a domestic preference for procurements, and this is also required to be put into state procurements. And it applies mostly to construction materials, and there should be a preference in there for materials that are produced in the United States. Similarly, with section 323, also required to be in state procurement documents, is the requirements for following the EPA guidelines when you're expending over $10,000 and when you're procuring waste management services. And then section 324 is the requirements for doing cost and price analysis. And that's very detailed, and we're going to touch on that a bit more in this presentation. You find the requirements under section 325 for a federal award agency or the pass-through entity review. And high level key to that is that you must allow the federal awarding agency or your pass-through agency to review your procurements when that's requested. Then section 326, this too relates to construction, but this is the bonding requirements. and it'll touch on your bid guarantee bonds, your performance bond, which has to be 100% of your proposal, and your bid in your payment bond, which also has to be 100% of the proposal. But you want to definitely get in there and understand those bonding requirements. And then the last section is section 327, which are the contract provisions. And those contract provisions are actually in Appendix 2 to 2 CFR 200. And these requirements need to be in all of your contracts once you have actually procured a vendor and you are ready to contract with them. So now I'm going to hand it off to Kevin and let him continue with more discussion on procurement. Thank you, Kevin.
You're welcome. Thank you, Deborah. What we want to do now is quickly turn our attention to the different types or methods of procurement that are permitted under 2 CFR Part 200. Specifically, there are 5 different types or approaches that we want to touch on today. The first being micro purchase, and it has recently been updated in terms of the dollar value limit, and it is currently anything under $10,000 for purchases, and it's really for commodities such as supplies, materials, etc. However, be aware that if you are purchasing for any type of a capital project that includes labor, specifically construction labor, the $2,000 Davis-Bacon threshold still remains in place. When we conversely talk about small purchase, the federal small purchase procurement limit, as previously mentioned by Deborah, is now been established at $250,000. And essentially what we're looking for here are simple, non-complex acquisitions of supplies and potentially services that could be something as simplistic as a janitorial service or other types of things. And in that, we're looking for a simplified approach. We're still going to require price or rate quotations that can be done on an informal basis. So it may not require, depending on local standards and requirements, a formal solicitation. But again, if your small purchase limit is a lower dollar threshold, you may be required to follow more stringent steps. Moving on to our next slide, you'll see some of those steps now. So Jasmine, can we move on to slide 14, please? Here are the more formal structured approaches which require, for example, under sealed bid for construction, a formal advertisement. And that formal advertisement will talk both about the opening and the closing of bid. It will provide for information related to questions. It will also, if it is construction related, it will have to ensure that if there is an update in the local wage determination, have to be issued to any eligible potential bidder. So in this situation, we're looking at a sealed bid, and a firm fixed price or lump sum will be awarded to bidder who is the most responsible in terms of complying with the terms and conditions of the procurement itself. All right. When we now look at the other approach of the more formal standard, which is competitive proposal, that can actually be broken into either a request for proposal, which does include price, or a request for qualifications, which could be based on experience and not necessarily factored into a price consideration. So in looking at this, we need to understand clearly that if we are hiring someone who is providing a general service, for example, it could be a construction inspection service, it could be for interviews for compliance with wage determinations or labor standards, it could also be review for environmental approval and clearance. Those types of tasks could be done by a general professional services firm, as opposed to a professional service which may require a state certification, such as an architect or an engineer. So depending on the type of service and the type of professional professional services necessary, it will determine whether a request for qualification or a request for proposal will be met. Next slide, please. The final approach that can be used is non-competitive proposals. And this typically is only for emergency situations, and those situations where there are circumstances that present itself where formal procurement processes cannot work. This is a procurement approach or solicitation method that you may see, for example, under projects funded by FEMA for immediate disaster recovery assistance. But under the HUD and the CDBG program for disaster recovery, as well as for mitigation, many of these events have occurred in a prior period of time, and that emergency situation, in fact, can no longer be justified or documented. So the non-competitive proposal is not one that is typically used under the CDBG-DR programs. Now, continue to remember or remind yourself that receiving a sole bid or proposal is not necessarily comparable to a non-competitive procurement approach. You may go out and find that you have limited responses. That's different and distinct from a non-competitive proposal. Next slide, please. What we want to talk about, and the most important thing as we walk through the different approaches, is the significant importance of planning. We must understand clearly that we need to know who will be carrying out a duty, function, or task. Do we, as a grantee or a subrecipient, have that capacity in-house? If we do not have that capacity, can we, in turn, go out and procure that, whether it is a professional service or whether it is a sealed bid for construction projects? So when we take and look at these different approaches, whether it's a request for proposal, and what I like to always use is a little ditty, as I call it, RFP means we're also going to have a price as opposed to an RFQ, which is really qualification. So if I'm using an RFP, price is a factor of selection and consideration. If I'm using an RFQ, qualification is not based on price, but could be negotiated once qualifications are established. And then finally, invitation to bid or sealed bid would be used for construction and must have a firm fixed price included within it. Next slide, please. When we talk about the cost and price analysis, the federal simplified acquisition threshold of $250,000 is identified here. However, it is important to understand, as Deborah had mentioned previously, that if there is a state or if there is a local standard that lowers that dollar threshold to a point where it could be as low as $10,000 or even $5,000, you will be required to document that based on the individual recipient or subrecipient's policies and procedures. The key here is this, that the non-federal entity must make an independent estimate before receiving a bid and proposal. This establishes the cost reasonableness and also conforms with the standards established in 2 CFR Part 200. One of the biggest single factors of procurements being disqualified or identified as being not compliant is failure to conduct this cost or price analysis at the time the procurement is conducted. You are permitted to negotiate price as a separate element. It is important to understand if there is no price competition, then the cost analysis is still needed to be performed. Next slide, please. When we look at documenting the procurement process, it's important to be able to establish the history of all steps taken, including the planning steps, as well as the update for the policies and the procedures that your procurement department uses. A checklist of items to go through the process step is always helpful, as well as the approach for the independent cost or price analysis. Some of the independent cost of price analysis may be based on historical contracts that have been let over a number of years. For example, if there's a history of engineering contracts or architectural contracts. The key here, again, goes back to understanding that if I am using an integrated purchasing system where I may have pre-qualified vendors, or I might be tapping into a database of potential contractors, that opportunity is not precluded or excluding any other eligible entity from engaging in or solicit or participating in the procurement. The other thing that I would recommend strongly is developing a procurement plan. If you're doing capital projects and you know that you may have 4 or 5 projects within your portfolio and will need to have architects or engineers or contractors, develop a plan and a schedule. And then finally, the last part and the important part is how do I monitor to ensure that this procurement has undertaken and complied with the appropriate steps. For state entities, a number of state grantees currently are requiring that the subawardees provide documentation and information related to their procurement procedures in advance before they go out into the marketplace so that procurements don't cause problems of ineligible costs later in the process. Next slide, please. These are some common mistakes, and I want to move on because I know many of you are interested in the Section 3 discussion, but if you look at this, I like to call this my top 10 of things not to do. So for example, failing to engage in full and open competition, not conducting a cost or price analysis, not including the required contract clauses, failing to review for excluded parties, and finally, not having either a price or contract ceiling or using a cost plus percentage of cost contract. So those are some of the common mistakes that are identified by the Office of Inspector General, as well as other federal agencies, whether it's FEMA or the Department of Transportation. And finally, the last discussion on this point I want to bring up are a couple of elements that are needed in the next slide, specifically that those elements, can we move to the next slide, please? Finally, those elements included are, in terms of contracts, specifically under your consolidated notice, they must be posted on your disaster recovery website, including your procurement policies and procedures and all contracts, except those that are under the micro purchase threshold. So the key here is not only do you have to be open and transparent about the policies and procedures, you must also have your contracts listed on your public-facing website, and it must include a summary of the description and the status of services or goods procured by both the grantee or any sub. Having said that, I'm going to move forward. We're a little behind schedule, and we're going to get into our discussion on Section 3.
Thanks, Kevin. And Jasmine, if you could just pass the presenter ball to me, that would be great. Okay, so now we're going to segue into Section 3. As you all may know, HUD published a new Section 3 final rule on September 29th, 2020. It went into effect on November 30th, 2020, and compliance on the new regulation began on July 1st, 2021. So what is Section 3? The purpose of Section 3 is to ensure that employment and other economic opportunities created by HUD financial assistance is directed to low and very low income persons and to business concerns that provide economic opportunities to low and very low income persons. These efforts should be made to the greatest extent feasible and consistent with existing federal, state, and local laws and regulations. Section 3 applies to a variety of HUD programs, including CDBG-DR. One of the most important definitions that you'll need to know is the definition of a Section 3 project, and you'll also need to understand how it applies to a project. The final rule defines a Section 3 project as a site or sites combined with any building or buildings and improvements located on the site or sites that are under common ownership, management, and financing. Section 3 Section 3 applies to projects that are fully or partially funded with HUD financial assistance, and we'll get into some of the thresholds in the next couple of slides. So this is a list of key definitions. You'll want to know what a Section 3 worker is, what a targeted Section 3 worker is, and what a Section 3 business concern is. For the purposes of time, we will not go over that today, but I do recommend that you visit the HUD Exchange, and on the HUD Exchange, you'll see Section 3 training materials where HUD conducted a Section 3 training series last year, and that training is recorded, so you can go back and review that training to get a better understanding of Section 3 worker, targeted Section 3 worker, and Section 3 business concerns. We will be reviewing safe harbor as well as labor hours for the purposes of this presentation. So now that you understand what a Section 3 project is, the next thing that you'll need to understand is if Section 3 applies to your project. So under the final rule for HCD financial assistance, Section 3 applies to housing rehab, housing construction, and other public construction. I do want to note that Section 3 does apply to demolition projects, whether it's a standalone project or it's included in any one of the other applicable projects. So that's one thing to note. For HCD assistance, Section 3 applies if the total amount of HUD assistance for the project exceeds $200,000 from one or more HUD programs. So notice that I said exceeds $200,000 from one or more HUD programs. So you're looking at the total amount of HCD assistance. And if that total amount of assistance exceeds $200,000, then Section 3 would apply. And it would have to be a housing rehab project, a housing construction project, or other public construction project. So as you can see, Section 3 applicability is determined at the project level. I do want to note that Section 3 does not apply to material supply contracts or Indian and tribal preferences. You'll also need to understand the legacy and transition project timelines, as you'll need to determine which projects and contracts fall under each category, as this will impact the contracting process. So contracts executed or projects in which HCD funds were committed prior to November 30th, 2020 are required to comply with the old rule, which is Part 135. For legacy projects, recipients will be expected to maintain records of compliance, but will no longer be required to report Section 3 compliance to HUD and SPEARS. Also, HUD does not require recipients to change or alter contracts that were in place prior to the new Section 3 requirements becoming effective on November 30th, 2020. Transition projects are projects where assistance or funds were committed between November 30th, 2020. As you recall, this is when the final rule became effective, and July 1st, 2021, when compliance on the final rule began. These projects are subject to the new Section 3 regulations, and recipients will need to follow the final rule for new grants, commitments, and contracts that are executed during this transition period. Specifically for transition projects, recipients will be expected to maintain records of compliance for these projects, but will not be required to report to HUD and SPEARS. I do recommend that you review the guidance that HUD issued last year on, it's the OBGA notice, CPD notice 2109, about reporting and how to report on projects that fall between the transition period. I won't get into that for the sake of time, but I do recommend that you do go to that notice and take a look at what the notice says about reporting. As mentioned previously, the final rule tracks and reports labor hours instead of new hires. So for HCD assistance, labor hours are hours worked by all workers employed on a Section 3 project. And you'll want to note here that there is a special category of labor hours called professional services labor hours. And these labor hours that are professional services labor hours are excluded from the Section 3 requirements. You can refer to the Section 3 requirements, Part 75, to get a definition on on professional services. But one thing that you do need to know is that they're excluded from the requirements. However, there are opportunities to get credit or a bonus, essentially, if you do have Section 3 workers and targeted Section 3 workers working on your Section 3 project, and they do fall within the professional services labor hour category. So if you have folks who are Section 3 workers and targeted Section 3 workers that are working on a Section 3 project, you can report in the numerator when you do your calculations on those labor hours, but you would not report them in your denominator, and essentially you could get a bonus. But if there are no Section 3 workers or targeted Section 3 workers who fall within this professional services labor hour category, then you're not required to report on them. Okay, as mentioned earlier, there has been a transition in focus from new hires to labor hours under the final rule. So under the final rule, recipients will be considered to have complied with the Section 3 requirements and met safe harbor if they certify that they have met or exceeded the Section 3 benchmarks, which we'll get into in a few, and followed the required prioritization of effort outlined in 75.19. I will not go through the prioritization of effort for the sake of time. However, I do recommend that you do go to 75.19 and take a look at what the regulations require under Subpart C for Housing and Community Development Financial Assistance. So to meet the quantitative benchmarks of the safe harbor provisions for CDBG-DR projects, 25% or more of all labor hours on a project must be worked by Section 3 workers, and 5% or more of all labor hours on a Section 3 project must be worked by targeted Section 3 workers. Sorry. So that's 25% of all labor hours must be worked by Section 3 workers, and 5% of labor hours must be worked by targeted Section 3 workers. And I do want to note that you have to meet both goals, both benchmarks, in order to be in compliance with the final rule. I also want to note that the 5% goal is contained within a 25% goal. So all targeted Section 3 workers are Section 3 workers, but not all Section 3 workers are targeted Section 3 workers. If you're unable to meet the benchmarks, you can report on qualitative efforts, and we'll get into and provide a few examples later. But I do want to note too, something important to note as well. You'll notice that there are no contracting quantitative benchmarks for contracting. However, the final rule does outline kind of the efforts that recipients need to make to do or to make best efforts to direct, business contracting opportunities to Section 3 businesses under 75.19. So once again, to repeat, because I got tongue-tied, there are no quantitative benchmarks for contracting. However, you will be required to follow the prioritization of effort requirements outlined in 75.19 when it comes to notifying Section 3 business concerns about contracting opportunities, etc. So now I'm going to walk you through how the Section 3 requirements impact the Section 3 procurement and contracting process. The Section 3 contracting process starts in the planning phase and extends all the way through pre-construction phase and post-construction phase. Although in this presentation, we're only focusing on procurement and vendor contracting, there are some other things around reporting, making sure that you include reporting requirements if you're going to be doing any type of remediation if contractors are not complying with the final rule. You'll just want to make sure you include some of those things in your contracts, in your procurement documents, but I won't touch on them. I might touch on them a little briefly later, but I won't go into depth. I'm just going to focus specifically on what the final rule kind of says about what should be included in your bid documents in your contracts. So starting at the Section 3 plan phase, it's highly recommended that you develop a Section 3 plan before you start developing your bid and proposal documents. It's not required, but it's a best practice and it's highly recommended. And as you can see here, we've listed a few components that you may want to consider including in your Section 3 plan. So the Section 3 goals that I just reviewed, the 25% and 5% benchmarks, the Section 3 worker and targeted Section 3 worker certification procedures, as well as certification procedures for Section 3 business concerns. You'll want to outline that prioritization of effort that I just mentioned earlier, as well as qualitative efforts that you, as the recipient, your contractors and subcontractors and subrecipients may take to attempt to comply with the Section 3 requirements. Sorry, guys, I've noticed I wasn't advancing the slides. So just so you guys can see, I just mentioned the first few items here, and then I noted some other items here. So reporting, monitoring, and documentation requirements, we won't get into that, but those are some things that you may want to consider including in your plan as well as in your contracts. If recipients are unable to meet the Section 3 benchmarks, then they are required to report qualitatively on efforts made to attempt to meet the requirements. Here you'll see a list of examples that the contractors and subcontractors could do to ensure that opportunities are being communicated to workers. These examples can be outlined in the planning phase. Like I just mentioned, you can include this information in your plan and kind of plan plan ahead of time before you inform your contractors on kind of the efforts that need to be made. And then also to help them understand the types of qualitative efforts that you as a recipient are requiring them to do. A few examples include utilizing HUD Section 3 Opportunity Portal to post contracts and search for Section 3 business concerns, coordinating mandatory pre-bid meetings to inform Section 3 business concerns about opportunities, advertising contracting opportunities to Section 3 business concerns. You will want to advertise in places where they read information or where they congregate, whether it's like the Chamber of Commerce or if you have a minority business entity that's located in your community, you'll want to make sure that you're communicating those opportunities through those various channels. Section 3 business concerns may self-certify as a Section 3 business concern during the bidding or contracting process. The Section 3 status of that business should be verified before you award any contracts or subcontracts. Once a business is certified as a Section 3 business concern, it will retain that status for as long as it continues to meet the definition outlined in the regulations. However, I do want to note that recipients are responsible for maintaining certifications to verify eligibility. So if you do plan on using the Section 3 opportunity portal to identify Section 3 business concerns, you're still responsible for making sure that you basically keep those certifications, Section 3 business certifications on file. Also, certification status is good for 6 months. So if you're working on let's say a year-long project with a contractor and the contractor is a Section 3 business concern, you'll want to make sure that after that 6-month period has passed, you get them recertified again. This next slide is just showing you a sample form of what a potential Section 3 business concern form may look like. I do want to note that there are a host of tools similar to this that are on the HUD Exchange where you can go and see kind of what a potential Section 3 worker certification form looks like or Section 3 targeted worker Section 3 form looks like. And so there are a host of tools on the HUD Exchange, and you'll be able to find this sample form on the HUD Exchange as well. And we'll link to that. We'll go over that later when we discuss resources. Under the final rule, you will be required to include language applying the Section 3 requirements to any subrecipient agreement or contract for a Section 3 project. Recipients must also require subrecipients, contractors, and subcontractors to meet the prioritization of effort requirements that I mentioned earlier, outlined in 75.19. So I recommend that you go review those requirements. HUD has not issued any language yet. We get that question a lot. So you may want to consider consulting with your attorney to help you draft language, or one of the recommendations that we receive from HUD is potentially using the old clause, the clause from the old rule, and kind of adapting that to the new rule. And so right now, once again, HUD hasn't issued any language yet to date, but I do recommend that you consult with your attorney to develop your own language. So in addition to the Section 3 provisions, you may also want to consider including language about reporting. So what's the reporting timeline? What do the reports look like? Are there certain requirements that you're going to require of your contractor to make sure that you're collecting those benchmarks and those labor hours for Section 3 workers and targeted Section 3 workers? Also, Section 3 record keeping, there are a few requirements. I recommend that you go back to the final rule and kind of look at those record keeping requirements because it outlines the types of records that must be maintained and for how long they should be maintained. You'll also want to consider including monitoring requirements in your contracts as well. If you do plan on penalizing contractors for not complying with Section 3, if you desire, you can include that in your contracts as well as any corrective actions to remedy non-compliance. A few more types of documents that you may want to consider including in your contracts could be the Section 3 plan. So, for example, you could have your contractor at the time of bid fill out a Section 3 plan, basically laying out how many labor hours they expect that may be generated from that contract, how many contracts they expect could be generated from that contract, and then outlining how contractors will meet the prioritization of effort requirements and kind of do outreach to Section 3 workers and targeted Section 3 workers, as well as Section 3 business concerns. You'll also want to include a Section 3 business certification form in your bid documents, not in your contract, just to make sure that, you know, at the time of bid, they're certifying that they're a Section 3 business. And then once again, it's good for 6 months, and then you'll have to recertify them if needed. And then also you want to make sure any accompanying certifications outlined in 75.31, those worker certifications, employer certifications, or other certifications are included with that Section 3 certification at the time of bid. A few best practices. I'm going to take you briefly through this just because of time. During the pre-bid phase, we recommend that you implement a process for determining Section 3 worker and Section 3 business eligibility. So once again, if you develop a Section 3 plan, ideally the Section 3 plan outlines how you'll determine whether or not a person qualifies as a Section 3 worker or a targeted Section 3 worker, as well as if a business qualifies as a Section 3 business. You'll also want to consider holding Section 3 workshops, mandatory pre-bid meetings, as I just mentioned, to communicate requirements and goals, as well as providing copies of your plan to contractors. In the next stage, you'll want to consider, as I mentioned previously, having your Section 3 or having your contractor fill out a Section 3 plan at the time of bid, as well as certify if they qualify at the time of bid. And then at contract award or prior to execution stage, contractors can provide a list of all the workers and contractors that they expect to work on the project, as well as confirm that the contractors, you'll want to confirm that the contractors are not on the debarred list, as mentioned earlier in our presentation. If there are new hires and subcontracts are required or generated from the contract, you'll want to make sure that you provide your contractor with a list of potential qualified Section 3 workers and targeted Section 3 workers, as well as provide them with a list of potential Section 3 businesses. In addition to that, you can encourage your contractors and subcontractors to utilize HUD's opportunity portal to find Section 3 workers, targeted Section 3 workers, as well as Section 3 business concerns. So a few things that you'll want to make sure that you consider now that we have this new final rule is updating contract language for projects that fall within the transition period that refer to the old rule requirements. So earlier I went through legacy projects and transition projects. So if you currently have a project that's a transition project, then you'll want to make sure that any contracts that reference the old rule now reference the final rule of Part 75. So you'll want to update old rule references. You'll want to amend your contract to include the Section 3 provisions. You'll want to swap out old definitions. So for example, we're no longer using the term is not Section 3 residents, it's a Section 3 worker, as well as targeted Section 3 workers. And then you'll also want to, as I mentioned earlier, think about including your new reporting requirements, complaint procedures, language about change orders, et cetera, into your contracts. Most importantly, you'll want to consider local, state, and federal procurement requirements while developing your contracts in your bid documents. That is just one of the things that's key to this is just remembering that you'll want to consider your local, state, and federal procurement requirements to make sure that you are in compliance with all of those requirements. And one of the questions that we get a lot is about the preference, the Section 3 preference. And the final rule does not outline a preference. However, if you do, as the recipient, you do want to implement a preference, you'll just want to make sure that it's in line with local, state, and federal procurement requirements. In addition, projects that involve multiple sources of funding will impact definitions around targeted Section 3 worker, as well as the prioritization of effort, as well as reporting requirements. So you'll want to make sure you keep note of that. Also, existing projects may trigger Section 3 compliance even after the initial commitment date. So if other HUD funding or additional HUD funding is added to a project, where previously Section 3 maybe would not have applied, but now that you have this additional funding added to the project, it may or may not apply. The way that you think about this is the funding expected or unexpected? So change orders are typically not anticipated. So if you have a project that did not meet the over $200,000 threshold as far as the total amount of assistance, HCD assistance, did not exceed $200,000, and you have a change order that brings it over that amount, that's an unexpected change. So then you would not be required to comply with Section 3. You could still stick to your old contract. However, if you have a project where you're phasing and it's planned, then Section 3 would apply cumulatively to the project. So at the onset, you'll want to make sure that the Section 3 requirements are included in your contracts, et cetera. And so there is information in the OBGA guidance and the Section 3 FAQs that kind of outline and detail this, but I also recommend that you consult with your HUD field office rep on this if you still have questions. So now I'm going to turn it over to Jasmine. Jasmine.
Thank you, Tiara. So for this session, we've compiled some helpful resources to guide grantees as they work through developing and implementing procurement and Section 3 into programs. The first featured resource here is the Buying Right CDBG-DR and Procurement Guide to Recovery. This HUD toolkit is a resource for grantees and subrecipients to use to understand procurement and how to comply with the requirements. The next featured resource for Section 3, we are providing some Section 3 quick links, a link to the Section 3 Final Rule CPD notice, as well as links to different Section 3 trainings and tools that are available on the HUD Exchange. And also, we like to highlight that the Disaster Recovery Tools and Templates Library is available as a resource to help you guys, well, to help everyone with disaster recovery and mitigation grants. The library has been organized to help grantees prepare and design their programs. And it's in a centralized location for ease of access. And lastly, we are providing links to the HUD Exchange, Disaster Recovery homepage, Mitigation homepage, Tools and Templates Library, and the 2020 CDBG-DR Grantees homepage. Now we'll transition over to, questions and answers. We don't have a whole lot of time, but I think we can possibly take on 2 or 3 questions. So
I can answer. We received a question about someone said a subrecipient reached out to them regarding concerns when workers are paid in accordance with Davis-Bacon wage requirements. Those Davis-Bacon requirements could be in conflict with Section 3 requirements. Do I foresee any issues with this? And I suspect, hopefully I answer your question correctly. If you do have a project where it's a Section 3 project and Davis-Bacon applies, all you need to do is just make sure that you collect those certifications from the Section 3 workers for those people who do qualify as Section 3 workers and targeted Section 3 workers. And you'll want to collect the total labor hours. And then provided that you don't meet the benchmarks, you'll just want to make sure that you can report qualitatively on the efforts that you made to attempt to meet the requirements. So that's just the short end of the answer. But I did want to take that one because we get that a lot.
thank you. We did get another Section 3 question. The question is, I understand we can use individual income rather than household family income for Section 3 worker eligibility. for determining whether a business concern is a Section 3 business concern using 51% owned, controlled by low or very low income persons. Do we use individual income or family household income?
Individual income.
And let's see, I think we have time for a couple more. I'm coming. Do legacy projects have to report in DRGR?
No, so if I go back to, and I hate to take up the time, I'm going to turn it
Well,
over to
there's
Deb.
actually, let me just, this was answered in the panelist, and it's the legacy projects under the old Section 3 rule are not posted in DRGR, but the grantee should maintain records showing Section 3 compliance in their files.
Thanks, Kevin. I was going to go to the slide.
And
By William Bedford from HUD.
okay, thank you.
Well, I wanted to bring up, I know that we have more questions than we have time for, but one thing I did want to come back to specifically for procurement is the following. What we're seeing repeatedly and challenging both subrecipients and subawardees is attempting to qualify a prior procurement under the federal standards and trying to retroactively qualify a procurement action, in some cases a year or two before the actual award of the funds, is going to be challenging, if not at all difficult, to comply with these standards as we discussed this morning. So my response or my suggestion to all recommendation is to simply state, even if you have someone under a current requirements contract or a retainer contract, do not assume that you can simply just use those on-call services. You should plan and prepare to individually procure moving forward. By updating your policies and procedures specifically for procurement using federal funds, it will cover a host of other funding sources beyond HUD and will permit your local unit of government and your procurement officers to comply for other critical elements that could include transportation, human services, and health.
Thank you, Kevin. I believe that's all we have time for. So we will conclude this session. I do want to remind everyone to continue the conversation with HUVA. On the site, you'll be able to explore professional profiles of event speakers and attendees, send in-app messages, and exchange contact info, access event agendas, and a whole lot of other good things. I want to thank Kevin, Deborah, and Tiara for presenting today, and thank you to everyone for attending the session. And that is the end of the Understanding Procurement and Vendor Management session. Thank you. Bye-bye.